We are back.
Back. No,
We
I got
are.
a little sparkling ice.
Nice.
All right. Well, freaking welcome back to another edition of Live Feed Read. I'm at the office of that freaking fiasco that
Yeah.
went on last week, which was all Jason's fault, not mine, by
Yeah.
the way.
Ah.
Well, it won't happen again.
Uh,
Jeepers creepers. Christmas and the end of the year are right around the corner.
right here.
It's
Right here.
insane. Glad we're
How's your
still
20-foot
here.
Santa? Did the
Oh
storm
yeah,
carry him off?
Jason called on last week during that little tropical system, and I got this big 20-foot Santa. It's funny as heck, and I look outside and it's blowing down the street. I'm trying
Oh
to
no.
I'm trying to finagle this thing, and Jason calls. I don't even know what I said, but something like, "I gotta go, bro."
Yeah.
And so I
Yeah,
forgot
you
all
hung up
about
on me.
it,
I was like,
and
well, all right.
I didn't call you back, did I?
No.
Oh, yeah. Try to restake a 20-foot Santa that's blown up and in a 90-mile-an-hour wind. I'll
Yeah.
tell you what, it led to a beer or two. But yes, Santa is
Oh.
fine. He's well. He had to get cleaned off with the hose, and so he's good. All
Good,
right. So
good.
interestingly enough, I was looking for a topic, and I found the follow-up on a Supreme Court case that we had talked about several weeks, if not months ago. And
Okay.
it was the Aitchison Hotels versus Loeffler. And
Okay, remind me about that one because that
yeah,
was
it was where Loeffler goes online,
it's a book or something, right?
looks at hotel websites to see
Oh,
if they have the ADA, American with Disabilities
amenities.
Act, verbiage on there as to
Yes.
what they provide by way of ramps and bathrooms.
Right.
And
Okay, right.
evidently, these hotels are required to tell or have a spot on their website that you can go to as a disabled individual to find out, the who, what, when, where's, and whys, so to speak,
Yes.
of the hotel. And
Right. Okay.
so whether it's you can stay there, so to speak. Well,
Yeah.
and I'm just going to read it. So this one was it was interesting. This one here was Justice Barrett. She is the one who delivered the opinion of the court, and she is, of course, a conservative, one of the conservative justices appointed by Donald Trump. And so I don't think when I'm reading her opinion, and again, it's not her opinion. They all, the majority have to agree on what they're going to do. So it's not her. They just someone gets to write it and they kind of put their own little spiel on it. But you don't just to say, "Oh, I'm deciding this." You with me?
Yeah.
All
Yeah.
right.
Yeah.
So let me read it. It says Deborah Loeffler, for those who don't recall, has sued hundreds of hotels whose websites fails to state whether they have rooms accessible to the disabled.
That was something that you discussed too, is that this wasn't her only case. There's like a series of cases. This is like a one-time
No,
thing.
no.
This was
She
she
and her
does this.
lawyer and others, I'll get to that, were making
Okay.
large
Okay.
sums of money on this. But let me continue.
Sure,
As,
go ahead.
as the sheer number of lawsuits suggest, she does not focus her efforts on hotels where she has any thought of staying, much less booking a room. Instead, Loeffler systematically searches the web to find hotels that fail to provide accessibility information and sues to force compliance with the American with Disabilities Act. Boy, that's so cheesy. Yeah,
Yeah.
going
Yeah.
to the hotel. She's not going to the hotels. She's not
Not
booking
even in
the
good faith.
hotel. And if I'm not mistaken, I think she lived here in Florida, and the Atkinson Hotel was in Maine.
Okay.
All right, so let's continue.
Okay. Yeah.
Let's see. Where was I?
Oh,
Ordinarily,
this is recent, December 5th.
oh yeah.
Okay.
Ordinarily, the hotels settle her claims and pay her attorney's fees, but some have resisted, arguing that Loeffler is not injured by the absence of information about rooms she has no plans to reserve. Only only plaintiffs who allege a concrete. Okay, so what they're saying is
That's
that,
hysterical.
yeah, well, they're arguing standing. And
Right.
standing is, look,
Okay.
if you're not going to be in, you have no intentions of staying in our hotel, reserving a room at our hotel,
Mm-hmm.
and possibly being injured by our lack of the information you're requiring,
Right.
you don't have standing to sue us.
It's kind of irrelevant to you. Yeah.
Well, yes, but it's just standing. So that,
But it's
okay,
called standing legally.
that's what
Okay.
it's
I got
called,
you.
right?
I got you.
All right. But some have resisted, arguing that Loeffler is not injured by the absence of information about rooms she has no plans to stay. Only plaintiffs who allege a concrete injury have standing to sue in federal court. You follow me with me?
Yes.
Okay. So Loeffler, comma, these hotels have argued, is suing to enforce the law rather than to remedy her own harm. She,
Right. Correct.
so she's like the little
Correct.
ADA cop,
And yep.
and not
Yeah.
really trying
Yeah.
to remedy
Yes.
something that's happened to her.
Right.
Okay.
Yeah. Arguing for the sake of being able to.
So interestingly enough, Loeffler has single-handedly generated a circuit court split. Let me explain. Well, let me continue. The Second, Fifth, and 10th circuits have held that she lacks standing, meaning because she has no plans of staying at hotels and booking rooms, her case has been thrown out. You
Mm-hmm.
can't sue these hotels. The First, Fourth, and 11th circuit. Now, mind you, in federal court, the 11th is Florida, includes Florida,
Okay.
Atlanta, Georgia, Texas, and so forth.
Okay.
Or is Texas the fifth? Either way, some of the courts have said she has no standing, lacks standing, and the others, as I cited, said that she does, meaning
Okay.
she can be the ADA cop. The others have said,
Okay.
no, you can't be the ADA cop. You have to, be harmed. So that's
Right.
how the case gets to a Supreme Court when there's a split, like we've talked about in the circuits. No
Can I ask a
different
quick
than
question for clarification?
shoot.
The way that you worded it, you said only plaintiffs who allege a concrete injury have standing to sue in federal court.
Well,
Is that
this
is
is
that
just
a
federal
known?
court. That,
Okay.
yeah, no, that
Is
is.
that like a known thing that's a part of like that is
Well,
what?
honestly, you have to have standing in any court, whether it be
Right.
state or federal. They're just
But
just,
injury is that the way that that's established?
well, she's alleging that these
Like, does it require injury? Because injury is
no, because she's
specifically
not
worded.
injured. Well,
Okay.
that's what the
That's what they're
hotels
arguing
argue,
over.
that
Okay.
she's not injured,
Okay.
and therefore she doesn't have standing. Some
Okay.
of the circuits have agreed. The other circuit says, well, you violated the law, and she's basically like the little ADA cop. So
Right.
in order to make you comply, someone has to sue you. You follow
Right.
me?
Okay.
She's
Yes.
the one.
Yes.
All right.
Yes.
So some have said, no, you don't have standing. Some have said, yes, you do. You don't have to actually sustain the harm.
Mm-hmm.
I think that's crap. I'm with the ones where she wouldn't have standing, but let's continue.
Well, because in my thought, I would think that the problem here is that suing for damages and attorney's fees is one thing. Suing for compliance should be another, where it's like, oh, okay, well, if they fix it on their website, problem solved. Thank you.
Well, I
That's
couldn't
it.
agree
Like
more, but
we're done.
that's not how it works, just so you'll know.
I know. I know.
Yeah,
That's what I mean.
there are individuals, and believe it or not, many individuals that
Yeah,
do
it's a
this
profit
type of business with, in my opinion, unscrupulous lawyers who will
predatory.
find that a business, has violated some law, some act, and then they'll sue you, and the lawyers get. Well, let's continue.
Yes. Yeah.
All
Yeah.
right.
Yeah.
So
I'll try to stop interrupting you. But,
yeah,
yeah.
raise your hand, and I'll
I'm
call.
sorry. Okay. Yes, sir.
After we granted review, we being the Supreme Court, the case took an unusual turn. In July, the United States District Court for Maryland suspended Loeffler's lawyer, Tristan Gillespie, from the practice of law for defrauding hotels by lying in fee petitions and during settlement negotiations. So the lawyer evidently lied as to the number of hours expended and what she should make by bringing these actions. Let me continue. You got to raise your hand, sit it down.
I'm just listening. Go ahead.
The court based the suspension on a report finding that Gillespie demanded $10,000 in attorney's fees per case, even though he used boilerplate complaints. Boilerplate complaints is you just change, you hit replace name, replace date,
templated,
and you file it.
Copy pasta.
Right. Yep. Okay. Let me get into that because they're citing stuff. In addition, Gillespie funneled six-figure sums to the father of Loeffler's grandchild for investigatory work that he never performed, raising the prospect that either Gillespie, the attorney, or Loeffler, the plaintiff, or both got a cut of the money. All right, continue on. Making matters still worse, if that ain't enough, the sanctions order against Gillespie also implicated Loeffler's former counsel of record before this court, U.S. Supreme Court. So this was a cluster, boy. They got caught. Hold on. Let's continue.
Got the receipts.
So that's kind of what was happening. Now,
yeah.
So following these revelations, Loeffler voluntarily dismissed her pending lawsuits with prejudice, meaning you can't refile them. With prejudice means you can't refile your lawsuit. Without prejudice, meaning for whatever reason you dismiss it, but you can file it at a later date as long as the statute of limitations hasn't run. So there is a difference with prejudice and without.
Right. Okay.
Okay. So with prejudice, she's done with these lawsuits. All right. Which included her complaint against Atchison, the hotel. So she dismissed that with prejudice. Okay. She then filed a suggestion of mootness in this court. Moot means there's really no longer a case to be decided.
Right.
It's moot.
Right.
You're with me? Pretty simple.
Yes. When you said she filed it, you mean Loeffler?
With prejudice, and so Atchison can't be sued again by me, and so there's really no case left.
Okay.
All right. Yeah. So
right.
At this point, Atchison. Now this is the kicker. At this point, Atchison had already filed its principal brief on the standing issue, and we deferred a decision on mootness until after oral argument. So they actually filed briefs. I believe they actually had oral arguments, and so they've expended a lot of money.
Yeah.
And let's continue. Loeffler does not argue that Loeffler does not argue that we must dismiss her suit for mootness. She acknowledges that we can address jurisdictional issues in any order we choose. And so we have the authority to resolve the standing issues. So even though she's saying you can and should dismiss it because it's moot, meaning there's really no case in controversy, the Supreme Court saying, well, we don't have to, because it says the mootness is an easy issue and standing is harder. She argues to refrain from having to resolve the difficult standing question. It's just easier to say goodbye. All right.
Yeah. Yeah.
Atchison, the hotel, on the other hand, stresses that the difficult standing issue is a reason that the Supreme Court actually took the case in the first place. Though Loeffler's case is dead, the circuit split is very much alive. So there's, A, B, and C say they're standing, and D, E, and F say there's not. So there's still a split that the Supreme Court could decide should they desire to do so. Right?
Yes.
All right. So this court has received briefs and heard oral arguments. All right. So for efficiency's sake, Atchison insists that we should settle this issue once and for all, rather than have to deal with it later.
Wait until it's filed again,
or until somebody else.
Right.
But remember, somebody else has to go federal court, appellate court, Supreme Court. Continuing on, hold on.
Yeah.
Moreover, Atchison warns that if we dismiss this case for mootness, the standing issue might not come back anytime soon. While Loeffler has disavowed the intention to file any more ADA suits, others will file in the circuits that sided with her, and hotels will settle regarding it as pointless to challenge in that circuit because they've already decided the standing issue. So
Right. Okay.
you're not going to
Yeah.
fight it if you're going to lose.
Right.
Because remember, to be sued, they've already almost conceded, yeah, we didn't have it.
Yeah.
And so their only argument was, well, she doesn't have standing because she wasn't going to stay at our hotel and had no intention to do so. In those circuits that say she does have standing and that doesn't matter, it's just how much you're going to pay at this point. And so Atchison is saying that's ridiculous. That's what should be decided. And they're, of course, wanting the court to say she doesn't have standing. Put an end to this kind of crap.
Yeah.
Okay.
Yes. I'm with you.
Okay. We are sensitive to Atchison's concern about litigants manipulating the jurisdiction of this court. We are not convinced, however, that Loeffler abandoned her case in an effort to evade our review. She voluntarily dismissed her pending ADA cases after a lower court sanctioned her lawyer. She represented to this court, Supreme Court, that she will not file any others. So Loeffler's case against Atchison is moot, and we dismiss it on that ground.
Okay.
However, we emphasize that we might exercise our discretion differently in a future case. So basically, they punted.
Okay.
It's moot. The case is dismissed. This lady's telling us she's not going to file anymore. And so thank you. Have a nice day.
Okay.
That's crap. That's sad because you know what? Someone else is going to file.
Because they could have put an end to it. Yeah.
They could have, one way or the other. Now, having said that, the justices get together, right? Okay, so they discussed, I guarantee you, whether this person had standing or not. Are you with me so far?
Yes.
You got to understand what's happening here.
So they punted it. And
well, there's 9 justices, right?
Yep.
Some conservative.
Yep.
Right? And some liberal.
Yep.
Well, in my opinion, as an attorney of 25 plus years or more, the liberal judges are going to say, well, look, somebody has to hold these businesses' feet to the fire and make them comply with the ADA. So we would hold that she has standing.
Okay.
Justice Thomas, on the other hand, wrote a concurring opinion, which is not unusual. And Justice Thomas is pretty blunt. I conclude that Loeffler lacks standing.
Okay.
So you've got one judge telling everybody in the world, if your butt comes back, you know how I'm ruling.
Got you.
No standing. So what happened was they punted because there's a judge, Roberts and maybe a couple others didn't really say which way they would go.
Right.
So they may lose. So what they did was they punted to say, well, you might, come back at your own mercy. We're not telling you how we would rule and whether you're going to waste a lot of money and time as that tester, that test suit person. You follow me? But I will tell you this, Judge Thomas told you, hey, you're out. So that's how that went, because they didn't get a feel as to how the Supreme Court was going to rule. Was it going to be 5-4 or whatever? So they just said, okay, well, let's just do this. Let's just kick it to the curb for mootness, and hopefully, other people will see it as, be leery of these types of cases, because you may spend a lot of time and money down the road, and we may dismiss it. You know what I mean?
And is Thomas considered one of the judges that would have been in the middle, like a deciding vote?
There's the right over here. This is right, and this is the left. Right? You see my screen?
I do. I see you. I got you. Okay. Oh my word. Okay.
Yeah. He way over there.
Yeah. So it didn't necessarily shut down the conversation then, as much as it's still just.
Well, it shut it down for now.
Yeah. Yeah.
So anyway, that's a follow-up on a case we
That's
did
interesting.
a
That's
while
so
back.
interesting. You know, a lot of people talk about the president and the power and who's president. It matters. I think the Supreme Court justices are so important. They may
Well,
even wield more power than the president, if you think about it.
they have more power than basically most people on the planet.
Yeah.
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 Oh yeah. And that's why
Ooh.
it's like the saying is you're really not electing a president. You're hopefully appointing a Supreme Court judge.
Okay.
Right. You
Yeah, I
know,
haven't heard that, but
I
that's
don't
it. Yeah.
know.
Yeah.
I don't think there's any, because there's only 1 year left for Biden to appoint someone. I don't think there's anybody planning on stepping down in the next year.
Mm-hmm.
But of course, if someone passes away, then he could elect someone.
Mm-hmm.
But that's the saying is you're really not electing a president. You're electing you're hoping to appoint a Supreme Court judge.
Yeah. Wow.
Yeah, let me
Yeah.
see.
Wow.
Judge Roberts, he's young. Thomas a little older, but I don't think he may on the deathbed. Judge Alito, Sotomayor, Kagan, Gorsuch, Kavanaugh, yeah, they're not very old. I think Thomas might be the oldest one. But
Okay.
interestingly enough, look at and they don't show them up. You got Yale, Harvard, Yale, Notre Dame. I don't think me at USF's heading to the Supreme Court. I didn't. USF doesn't have a law school, but I'm
Yeah.
just saying.
Oh, speaking of
I
Yale,
don't believe I'm on my way anytime soon.
I don't see a USF Supreme Court appointee.
Yeah,
Did you?
exactly.
There was a case. I'll tell you about it maybe later. We can discuss whether you want to review it or not. But it'd be very interesting. It was a case that was decided on by the court, and then Yale's internal committee did their own review of the situation and decided to um, remove the student from the school.
What are you
Um,
talking about? Say what?
yeah, there
What'd you
was
say,
a
Willis? What'd you say, Willis?
there was a student. I can't remember his name. I'll have to do the
Doesn't
research and bring
matter.
it up.
Somebody at Yale
Yeah, was accused of
recently.
yes,
Okay.
within the last year or two.
All
He was
right.
accused of mistreating women, a
Okay.
particular woman, and then the court dismissed the case, or no, they judged on the case after 3 hours of hearing all of the evidence, text messages, everything,
What
that
court? Just
he
a
was not
court.
guilty. A court, yeah,
Okay.
one of the
Not guilty.
local
All right.
courts, not guilty, and then Yale, the internal committee held their own review and
Right.
removed the student from the school.
Okay.
But in that hearing, his lawyers weren't allowed to testify for him. They weren't allowed to cross-examine the person who represented the female plaintiff in that hearing.
Well, I'll give you an example of the
It's
difference
really
between an administrative hearing or a civil court hearing, a criminal a case that everyone that's basically over the age of 18 has probably heard. O.J. Simpson. He was found
okay.
not guilty by a criminal court because it's beyond all reasonable doubt, so to speak, right?
Right. Yep. Yeah.
Well, in the civil case, it's a preponderance of the evidence, basically 51%. The evidentiary rules are different in criminal cases than they are in civil cases.
Interesting.
What is allowed in a criminal case or may not be allowed in a criminal case, vice versa, may be allowed or may not be allowed in a civil case. And it's my
So
understanding
yeah.
a
Go ahead.
lot more is allowed in a civil case than in a criminal case. Now, I don't do criminal law, but you got to remember,
Hmm.
in a criminal case, your freedom is at stake.
Yeah.
So you want to be extra cautious about convicting someone. And I'm not saying OJ was or wasn't any, but you want to be
Yeah. It was just,
extremely cautious on
hmm
convicting someone maybe for
The
something they
stakes are
didn't
higher.
do. So the rules and the evidentiary things are much tighter. In
I will send you an
a
article
civil
or two
case
on it
is money.
because I think you'd find it interesting.
So that
Um. Yeah.
if you violate the code of conduct of a college, that doesn't mean you're guilty of a crime. They can boot you.
Right. But
That's
if
it.
the evidence points to that you didn't,
No,
and then they still
the
remove
evidence
you.
not beyond a reasonable doubt that you did it.
Okay, valid distinction.
Also,
Valid
and I will
distinction.
tell you example, especially when it comes to these
Mm-hmm.
stalking types of things. The court, and I don't do criminal law, but I've seen some things where, like, one case of sending a bad text to somebody or so forth, an ex-spouse or girlfriend, it doesn't rise to the level of a felonious act, a criminal act.
Mm-hmm.
Well, that doesn't mean if I send one text to Jason's calling him some, anti-Semitic or
Sure.
or some threat, or you follow me? So the
Mm-hmm.
law, well, just one of them, maybe you were just pissed or whatever. You got to have two, you got to have three. And again, it's an example,
Sure.
but that doesn't mean that the college can't say, whoa, wait a minute. You sent this? Thanks for
Mm-hmm.
coming.
Yeah.
We're not going to wait for you to, do whatever it is, you may or may not do. You're out.
Mm.
Yeah.
I'm gonna send you the because I think there's more evidence than that, but I now I'm really curious to see what you think about it. So
All right. Well,
I'll send you the articles, but
We've been
anyway,
chatting for 30 minutes, and
yes,
Millie over here is ready to go home. She
she fell
usually
asleep.
leaves around 4 o'clock, and it's 4:15. So she's giving me the wrap
She's
it
out.
up sign. I want to
Yeah.
go
Okay.
home. So,
Well, let's do
you
it.
know what? If you haven't read the book, Jason, I'm telling
Yes.
you, the sad thing is, I've kind of been giving them out at the Christmas party here and there. And every
Yeah.
single person that's read that book just loves it. I got to figure out how to get the word out that this is a good
Yeah.
book. And I'll tell you what, for the 10 or 15 bucks, whatever it is, and I'm not in it for the money. I
Mm-hmm.
just want you to read a good book, I think. But you got to remember, there's a freaking chili recipe in here to die for.
Yes. Yes.
And
It is.
once you
It's
make
so
that
good.
recipe, you're the king of the kitchen.
Yeah,
I'm
dude. And the
telling
weather
you,
right now is perfect for chili.
chili dogs, for football
Yeah.
games, you make this chili, bro, and I'm telling
Oh
you, they're
yeah,
going to be like, whoa.
dude. It's so good.
All
It's
right.
so good.
Then, all right, well, get us out of here.
You
Merry
got it.
Christmas. Merry Christmas, because we will not be here. And Happy New Year, because we're done. This was our last show of 2023. We'll be back January of 2024. And so again, Merry Christmas, Happy New Year, be safe. Thank you, Jesus. Happy birthday, Jesus. Especially happy birthday. On that note, I changed my sign out so it says happy birthday, Jesus, and I was gonna put, the big 2023, like, 2023, but I'm thinking I will catch flack because I guarantee you someone will say, wow, you got to go back 6 years for this, or you got to go
Yeah, dude.
that. I'm like,
Somebody's mincing a number somewhere. Yeah.
line 3 is blank. But anyway, that's a little humor there. But yep, happy birthday, and we're gone.
You got it. You got it.
Read and read. It's like having a lawyer in the family.